introduction, so I'll keep it really short. We're going to hear from Professor Henry Smith from Harvard Law School about the ecology of the common law, and then Professor Robert Thomas, who's doing a visiting chair here at William & Mary and is the director at the David Key firm in Honolulu.
Yes.
We'll talk about the new property, and then we're going to hear from Justice Ken Bell, formerly of the Supreme Court of Florida and now a shareholder at the Gunster Law Firm in Tallahassee, and he's going to share some insights with us on Stop the Beach Renourishment, the case that eventually went to the Supreme Court of the United States, but before that was in his court, the Florida Supreme Court. So thank you. We look forward to hearing from all of you. And then we'll do audience questions at the end, so save any questions you have for the end.
So thank you, Catherine, and thanks to Linda Butler for the opportunity here to do homage to Steve Eagle's work. Where is he right now? Okay. So actually this talk starts with a reference to Steve's work. I took the title as a sort of takeoff on one of the sections of a fascinating article he wrote in the Case Western Law Review, and entitled "The Common Law and the Environment." And there's a section in there called "The Ecology of Human Liberty." And so my title is "The Ecology of the Common Law," and you'll see how these little pieces fit together in terms of this wordplay that I'm trying to engage in here. All right. So the background to this is a problem that Steve has highlighted and has developed over a long period of time, and it's that well, to start with, the environment and the common law are often seen as being in tension in many ways, and I'll get into some of the specific ones in a moment, but there is this kind of tension between the common law and the environment that plays out in certain ways, especially in the commentary about property rights and the environment. One specific way that this comes up is when we get to nuisance or land torts like that. It's thought that nuisance, despite its being probably the most complicated and context-specific of the property torts, is thought to be inadequate to dealing with complex and widespread economic problems. And there's this kind of conventional history that nuisance wasn't up to the task, and that's why we got zoning and other land use and eventually environmental law. This is not, I'm not going to argue that nuisance or even public nuisance is some kind of panacea, but there's a very quick move from nuisance can't possibly handle it to now we'll just sort of put that aside and treat that as a sort of historical curiosity, and then when it's off to the races. Then, if we sort of look at what kind of is behind this thinking, it is actually a legitimate view of what the world is actually like, and especially when we get even towards problems like ecosystems, they're rightly seen as complex. And and it is thought, again, this is the conventional wisdom, that the very complexity of ecosystems sort of puts property rights on kind of wrong footing right from the get-go. That this is sort of a complete tension. Steve's work emphasizes the benefits of private ordering for the environment. So he kind of comes at it from the idea of spontaneous order and the idea that private ordering has beneficial effects. And what I'd like to do in this paper is to look at it from a complexity theory point of view. So take very seriously the idea that ecosystems and other problems involving land use and other problems involving property for that matter, and in this connection this would apply also to other kinds of more ethereal resources, that these are truly complex problems, and I'll get into what I mean by complexity in this context, because not all notions of complexity are equally useful here. But to sort of anticipate, the idea is that the private law sometimes uses modular structures, sort of breaks problems down into chunks to manage complexity. That actually private law is profoundly shaped by the complexity problem. It doesn't solve it completely, but it is not sort of completely unresponsive, and that it's actually its very shape is is a reflection of the very kinds of problems that people are rightly pointing to, and that this means that common law can evolve through a certain range, and that we actually do see common law evolution in these ways, at least through a certain range. Beyond that, top-down solutions may be required, but they are basically in this kind of hybrid relationship with the common law baseline, and we see this all over the place. Actually, just as an aside, as some of you may know, the issue of low-flying objects, namely drones, has been a very big deal, and Steve and I were quite involved in this. And part of the problem was that the common law was in the process of development, and people wanted to use common law arguments, sometimes in a very aggressive way in legislatures. I would say in a not correct way in legislatures, but the whole idea of how the common law and regulatory solutions have to come together is very important, and the common law sometimes doesn't get credit for being able to evolve to at least be a platform for regulation. So there's a puzzle here, I think, in plain sight. One, that ecosystems are complex, and going back to the legal realists, the common law, especially the sort of traditional versions of the common law, are seen as rigid and formal. And yet, the realists, partially in response to the complexity problem, or what they deemed to be the complexity problem, then portrayed property as a bundle of sticks, freestanding. We can kind of take the sticks in and out and so forth, which actually, if you really look at it, and this is kind of the main point of this paper, denies the complexity problem that we're concerned with in the first place. So just to refresh your recollection, the whole idea of a bundle of sticks is that we can identify a whole bunch of different rights to use and exclude and so forth, and right to destroy, maybe right to read a book on Saturday afternoon. There's an individuation problem, but once we've individuated these sticks, they are individual, and that the strong version of the bundle of rights, not every version of this, says, well, these are just sticks, and just like a real bundle of sticks, they don't interact with each other in any interesting way except to be bundled together. This, Alston, Mueller, me, so forth, a bunch of other people have started talking about, well, what if we took seriously the idea that the sticks interact with each other, and we borrow from well-known models in biological evolution, where we then put in these epistatic, or these connections between the different elements. So here's, 8 sticks in a bundle, and each of them is connected to 2 others. What happens then, as opposed to when K, the number of epistatic connections, is 0, or what if everything were connected with everything else? Those are 3 scenarios along the spectrum that are very different from each other. And when you play out the sort of evolution and fitness of bundles that look like either not connected, fully connected, or somewhere in between, you get this kind of difference. So if everything's connected with everything else, then as soon as you touch it, anything can happen. And sometimes that's that's sort of the idea of like, well, a complex problem must be that complex, sort of just total chaos. That can happen, but we shouldn't necessarily assume that that's true. That's kind of a counsel of pessimism. On the other hand, the bundle of rights picture, if you take it in the strongest form, is a complete denial of that K equals 0, no connections, and the fitness landscape, where if you change something, you go up or down in terms of fitness, and we can talk about what fitness means here. We can define it as we like. The idea is that if you optimize one stick, because there are no connections, you are definitely making the bundle better, because there's not going to be any effect on anything else. And so when you're doing that, you're evolving your way, either spontaneously or directly, up the side of this landscape that looks, it's called the Mount Fuji style landscape. And Mount Fuji looks pretty smooth from a distance. So complex systems that give rise to this are systems in which the interaction of the parts is what's really driving the story. It's very hard to trace some of the properties of the system to individual pieces, very unlike the sort of classic strong version of the bundle of rights picture. And so that gives rise to notions of adaptation, feedback, input, output, and self-reference. And key is that the properties of the whole are not trivially or easily traceable to the properties of the parts. And the idea is that this middle landscape then calls for managing the complexity, not throwing up one's hands, not assuming that we're always, making things better by tinkering with a micro part, but it's basically we have to structure the problem into components so that we make things better without upsetting the entire apple cart and so forth. So that brings us back to property and environment. So in the bundle picture, we assume the complexity problem away. And at the same time, traditional property baselines, not that they're perfect or anything, they're kind of regarded as an obstacle to dealing with this problem. They are, to a certain extent, a means for dealing with this problem. So the traditional baselines, to some extent, organize the complexity around just what we call a discrete resource, even though it's not truly discrete, is a reflection of this semi-organized complexity, not the Mount Fuji, not the anything goes, but somewhere in between. And so, we don't want to sort of assume that complexity always kind of works to the advantage of a disadvantage of the common law. It's really an empirical question. So the architecture of the common law, as I just mentioned, it permits it through a certain range to evolve in a beneficial direction. Now, there are some changes that might need to happen if there's a huge shock to the system, where you can't just evolve your way in incremental ways to where you need to go. And we've had big changes in the property system for good or ill when the civil code comes into being or things like that. And the idea then is that the common law has emergent properties. So emergent properties are properties of the whole that are not traceable to the parts. Water is wet, even though an individual water molecule isn't wet, and so forth. And so the question is, how far does private order get us? That is partly, you could characterize that as, are the desirable properties we're after going to emerge at the system level when private ordering is occurring? And you could call it a scaling up problem. And so if you look at, so on the one hand, libertarians tend to sort of say, oh, well, we have norms of possession and so forth, and transactions and so forth, and it scales up unproblematically. Non-libertarians of varieties of kinds see that will say that as we go up, certain other problems emerge that require intervention, but this is a way of framing that kind of problem. So that gets us to the environment. As Steve has pointed out, the sort of foundational idea, going back to Leopold and Muir, is that the environment involves basically massive interconnection. And some of the kind of rhetoric in those early sources was that everything is connected to everything else. That's sort of a first approximation, but we have to kind of get into what that actually means. It's certainly the case that what they were capturing was that environmental problems are very difficult because of these intense interactions and hard to predict ripple effects. Whether we're fully chaotic or not is a different matter. Now, to the extent that property rights respond to this kind of problem, they carry with them their own set of challenges. So, for instance, once you put an overlay of property rights on an interaction over resources, the property rights for transaction cost reasons, institution cost reasons, are going to be incomplete. We're not going to specify down to the level of my next physical movement and what I have a right to with respect to that, with respect to everybody else. We don't do that. And so the set of property rights themselves will have interconnections that do exist, don't exist, that can be manipulated by the participants. And part of the design question is where to put boundaries, where to sort of focus effort on countering strategic behavior. And so one of the articles that I circulated was, and that I'm going to draw on here, is my work on the semi-commons, which involves a hybrid of common and private property. And the worry is when people use a resource in common, they might be looking at it too much with a review to the private uses. The classic example that I developed is the medieval open fields, where it was common in one period and separate strips in another. And the idea is that we worry about people when they're put with one hat on, doing stuff that will harm people in the other regime or time period. This is a big problem. I'm not going to focus on open fields. I'm going to focus on what I've called in previous work. I'm going to take a new term, fluid property. Fluid property is one that can't be, where the whole idea of isolating chunks of the problem that I was invoking earlier is particularly difficult. So this includes water, it includes radio spectrum, it includes a variety of intellectual property in certain ways, and information. So here, the problem is twofold. On the cost side, it's very difficult to separate out fluid property. In a metaphorical sense, it's just moving around too much. And on the benefit side, in these situations, it makes sense for multiple people to use the resource at the same time. And those are very closely intertwined, because the more there's multiple use, the more it's hard to separate out what's going on. And so this means that exclusion strategies, just saying here's the resource and we're treating it as separate, is not going to work as well as it does when we're talking about rights to clickers or rights to chairs and so forth, or even rights to parcels of land at first approximation. And so it really forces us to enrich the notion of resource with the idea of governance. So who can use what, in what ways, and what ways are illegitimate. So this brings me to water law, and water law is actually a very interesting, water is a very interesting resource. It's connected to lots of other things. It also is a sort of a parable in property rights. It's a parable in law and economics of, well, under different conditions we get more parcelization of water law and so forth. That's true up to a point, but when you look at water law, and water law is sometimes put forth as the sort of paradigm of interconnectedness, what you find is, yes, a lot of interconnectedness, and in my terms, a lot more emphasis on governance than you do in other areas, and yet we find characteristic patterns. This is a reflection, again, of the complexity problem. It's not sort of all separation or all, like chaos. On the other hand, it's somewhere in between. And if we look at the two major systems of common law, water law, which is sort of a starting point, and it's now overlaid with regulation, you do find this mixture of exclusion and governance playing out in different ways in different areas. So let's talk briefly about, how much am I?
You're fine.
Okay, I'm fine so far? Okay. Time is a scarce resource too. So prior appropriation is the sort of characteristic of a number of western states, Colorado most famously. California has a hybrid system. Prior appropriation is thought often to involve more exclusion, because water was scarce, it was more parcelized. True up to a point. So first prime certainly has that flavor. When you transfer water, it is quantified in a certain way, but the idea is that that's at transfer. That's where it really matters. Otherwise, the rights are actually, interestingly, delineated traditionally in terms of use, and the delimitation is in terms of use. And if you go into some of the traditional sources, that's very clear, and it carries over surprisingly far. Very interestingly, a lot of people talk about the no injury rule. So when you transfer water rights to somebody else, and they might be at a different location on the water course, or they might have a different use, it is not permissible to then let that impact a junior user, somebody who was later in time, further down the water course, if they were depending on the return flow from your original use. So if I'm irrigating and there's return flow, and it's going to sieve, and he's using it as a junior appropriator, I have to preserve that return flow if even if I'm going to transfer to somebody else. And so that, that's complicated. It's a problem when it comes to transfer. It makes it more complicated, but it also means that from a static point of view, the people sort of have a way of counting on a greater flow of water that's appropriable and so on. There is a trade-off there, and it fits in with the idea that this is more of a governance regime than an exclusion regime than is sometimes thought. And this, of course, forms the basis for further regulation of public rights, as does the riparian regime, but it's interesting what the sort of jumping off point is. Here's a little diagram of return flow and interlocking rights, and Mark Kanazawa has a very interesting book on this. The idea is, if you're number one and you're transferring, you want to transfer to number two and so forth, you can't bypass three, and there's a complicated story. Then, of course, it gets even more complicated. I will not explain this diagram. But this is the Arkansas River ditch system, and this is a highly complex problem with multiple watersheds and so forth. Riparianism, it's often thought, well, it's like nuisance, it's all complicated, and nuisance is a garbage can of law, and blah, 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 and it's like, that's all complicated. Well, yes and no. So, first of all, the only people with riparian rights are riparian owners. Now, you might say, well, that's pretty obvious, but, it didn't have to be that way, and that's kind of exclusion. It's a pertinency. You are limited to using the water on the land, which is, makes sense under certain circumstances, and there are certain per se rules. On the other hand, it is true that reasonable use and so forth, shading off into sometimes it's a less well-known regulation of public rights, is more of a governance aspect. And the comparison to nuisance law, I think, is actually an apt one. Nuisance law, if you actually look at it, is a hybrid of exclusion and governance, and so is riparianism. So that's part of the picture. Now, finally, one thing that people sometimes say about property being kind of fusty and unsuited to the modern world is that they don't recognize that there are sort of extended forms of property. So even when we talk about corporate law, Burley and Means back in the early 30s said, well, because of corporations and all this division of benefit and control, property is dead. I mean, they didn't quite say that, but it's like, oh, well, this can't be property. Well, that's actually not true. It's that we have different kinds of separation, different kinds of governance as we move out towards entities. And Tom and I have dubbed this as sometimes entity property. Sometimes other people call it governance property, but the idea is that you have different separations, different governance, often very elaborate governance in other kinds of property, and that's certainly true, very, very true in the case of fluid property because of the governance the complexity problem that it inherently throws up. So mutuals and water districts are two kinds of entities with a different mix of public and private, and they do allow for separation of sort of group treatment and individual treatment, and there are separate functions within the entity that are made possible by delineating the entity in the first place. And it certainly makes intra-entity transfers easier, not necessarily external transfers, and this whole mix of entity property and public function is that Buzz Thompson has explored fits in with this fairly well. One thing one trade-off that I think is actually very interesting from Steve's point of view is that when we have governance property or entity property like this, or the semi-commons going back to the open fields even, or these kinds of environment, or these kinds of water situations that could be regarded as semi-commons with some private use rights versus public obligations and ownership. If that's the case, it's solving the governance problem at any given time can sometimes make the evolution of this more difficult because the rights interlock so tightly. Think return flows and so forth, or the strips on the open field, that it's very difficult to get from that regime to another regime. So there's a trade-off between solving a problem at a given point and making it feasible to keep your options open for the future. And whether that, in light of that, whether to design the private system with that more in mind, or to allow it to be very tightly interconnected and intervene periodically is a very big question. But this trade-off between sort of static solution and dynamic option is somewhat unavoidable, and I think that also resonates very much with Steve's work, and I very much welcome your thoughts.
Okay. It's a tough act to follow, but I will try. I don't have a slide. I don't have that. All right. Well, as always, I like to start these things by bringing you tidings of Aloha. From the state where the legislature thought it was going to lower the price of residential housing by taking fee simple interest from A and transferring them to B, the leaseholders. And where now, partially as a consequence, the median price for a single family, 2-bedroom, 1-bath, single wall house built in the 1950s hovers at around $800 grand. That talk about affordable housing. And also the state where the legislature thought that limiting the rent that gas companies could charge to their franchisees would somehow magically translate into lower gas prices at the pumps for consumers. And where now the price of gas is the highest in the nation. I'm sorry, Jim, we've taken that title from California, at nearly $4 a gallon. And in what may be a case of maybe 1 out of 3 ain't bad, you don't completely write us off out there in the 808. Our modest little jurisdiction is also responsible for at least one Supreme Court decision that we as property rights advocates really appreciate, and that's Kaiser Aetna, where the court both affirmed the right to exclude as one of those fundamental rights that is immune from interference by regulation unless it is first compensated. But also one of the overlooked holdings of that case put that right to exclude in the context of it not necessarily just being a fundamental right, because it was recognized by Hawaii law, but one that was sourced in the actions of the Corps of Engineers personnel who had confirmed via a Section 10 regulatory permit under the Rivers and Harbors Act that Kaiser possessed the right to keep others out of the navigable marina that it created by its own labor. So the court said, while the consent of individual officials representing the United States cannot stop the United States from claiming there is no property interest, it can lead to the fruition of a number of expectancies embodied in the concept of property, expectancies that, if sufficiently important, the government must condemn and pay for before it takes over the management of the landowner's property. And I mention that because Kaiser is a good lead into my portion of today's panel, which is focusing on public resources and private rights. And while we speak mostly of the term property, air quotes, as a private right, thanks in large part to our late colleague Charles Reich, whose place in the popular zeitgeist was secured by the greening of America, but whom we lawyers, I think, will always remember as the author of the very influential article, The New Property. And when I say influential, I checked the statistics, and I mean it is literally the most cited article published by the Yale Law Journal ever. And that article got us to thinking collectively about property in sort of a different form or a different format that maybe common law lawyers were not used to thinking about. Not exclusively as an instrument of private rights against the world, but most exemplified by the classic one, right? The right to exclude. What else is such an individual right against the collective? But maybe something that looked a bit more like the commons, things like government benefits, contracts, licenses, and what may be the most famous instance, Board of Regents against Roth, a government job. In that case, it was a poor sap teaching at a state college who lacked tenure. I feel your pain, brother. As we know, the court concluded that Professor Roth, who although he didn't possess tenure, if he could show that he had a certain entitlement, a new property interest, he couldn't be dismissed before the college conducted a hearing, in short, what we might call, as a shorthand, due process of law property. And in the more traditional takings clause property context, we've seen similar rulings from lower courts. I thought I saw Dana here, most prominently the Second Circuit in Brody against Village of Portchester. Asked Dana, right, and Robert about that. The 10th Circuit in a case called Mack Investment, which held that before condemning authority can declare your property blighted, that, of all things, how outrageous is it that they have to tell you that they're declaring your property to be blighted. And my own, for all the rap the Hawaii Supreme Court gets about not being terribly property friendly, at least in one instance, they followed the Brody rule and said that if the government is going to declare your existing permit to not exist anymore, that they do have some obligation to tell you about it, to trigger your rights to object. So, this raises the question, how have government-granted or government-recognized property rights translated beyond the scope of these individually owned? I mean, there's no question in that case, for instance, that Professor Roth had an individual right. And can these due process type of property rights be translated into the language that we talk about of rights that require compensation in the takings context? And I think two recent decisions kind of highlight the tension and the different ways that the courts approach them. And the first is quite naturally from my home state, again, of Hawaii. Now, you might think that given the amount of time I give the business to my home court, and was it David, was it 90% in the study that David Callies did of a certain time period in the Hawaii Supreme Court, environmental and certain other related interests won 90% of the time. That just gives you a flavor of what my daily life is like when I'm consulting with clients about their chances for winning. Our court finds a new property interest, or in this case, what I might brand a new property interest, I might rejoice. And that, as far as I can tell, no other state court before or since, and this was about 3 years ago, has recognized this property right despite it being in a number of state constitutions. And the court concluded that the Sierra Club possessed a constitutional property right in a clean and healthy environment, entitling the organization to certain procedural protections under the Hawaii Constitution. And interestingly, the court allowed the club to intervene in a public utilities commission petition regarding a power purchase agreement for what is now a defunct electric plant on Maui. And again, if it didn't quite sink in, let me read that again. The court recognized a property right in a clean and healthful environment. And I think the facts of that case are kind of worth going over because it involves a defunct pineapple plantation, which is about the most stereotypical Hawaii case that I could come up with. I mean, if I was creating a hypothetical about a Hawaii power plant, it would be one that was fueled in part by the waste of the excess pieces of a pineapple plantation. So Maui Electric filed an application with the PUC asking for the commission's approval of an agreement by which the sugar company, a sugar company and pineapple company, would look at additional charges and whatnot that would come about as this production using electricity, some coal and some of a byproduct called bagasse, which is, in this case, it's the excess after the molasses is extracted from sugarcane, as far as I can tell. And that would be then used as a biomass to produce electricity. But the problem was with this, the Sierra Club had a problem with it because it also used coal. So Sierra Club asked the PUC to intervene in the administrative appeals process from the Public Utilities Commission. I mean, it's shaping up as sort of your classic administrative challenge and the question of standing. The Sierra Club alleged that the agreement, if it went forward and allowed the power plant to go in place, would impact their members' health, aesthetic, and recreational interests and other things. And also they asserted their organizational interests in reducing the emphasis on fossil fuels, generally speaking. Now, that's pretty vague stuff, and that's generally the stuff you might expect to see in the legislature. But we see these in our courts in Hawaii all the time because we're not subject to Article 3 standing requirements, and the Hawaii Supreme Court's state standing doctrine can best be summarized as, come on in, the water's fine. Everybody gets to have a standing in court. And there's little doubt in my mind that if this case were instituted as an original jurisdiction action in Hawaii courts, that Sierra Club would have alleged standing. There's a famous case involving an inter-island ferry that would be docking at a state-owned harbor, and the court allowed the Sierra Club to intervene in that case because of the chance that the ferry might hit a whale. And so that shows you the extent to which standing is a very elastic doctrine in our courts, and for better or worse, that's what it is. But this case was it was an administrative appeal. It was not a question of standing in an original jurisdiction action. And so the question became, under the Administrative Procedures Act, may an outsider intervene in one of these quasi-judicial challenges, administrative appeal, some places call them contested cases, would put on your APA hat, enough to give it a seat at the table, a property interest enough to give it a seat at the table to challenge this through the administrative proceeding. And in that case, they applied the Board of Regents against Roth test. And if you can allege that you have some kind of property interest granted by statute or recognized otherwise in law, then that gives you the standing, the property interest, in order to have standing to challenge. And they argued that the members were concerned that the biomass plant relied too heavily on coal, and that was enough under the Hawaii Constitution. Has a specific provision in it that says everybody in the state has a right to a clean and healthy environment. Is that a property interest? And the lower court, the PUC said no. The lower courts, upon challenge in the courts, agreed and said no, that's really doesn't look like a property interest to us. But lo and behold, a 3-2 majority of the Hawaii Supreme Court reversed and said no, this is indeed a property interest for purposes of administrative standing to challenge this through the PUC process, And what I thought is that different in kind, gives you, property interest to give you standing, new property, whatever it might be. Is this different in kind than property that might lead to compensation? Is this the first step towards that? And what the court said is each person has the right to a clean and healthful environment as defined by our laws relating to environmental quality. Okay. Well, they said that created a legitimate claim of entitlement, again, putting in the language of Roth against Regents, and it is a property right, and here's kind of what I thought was really interesting to me. It said it's a substantive right, so it's not just a procedural right to have standing. It's a substantive right that you can enforce, and through the administrative process, but I think because of our low standing requirements, there's no reason absolutely that you cannot enforce this right through an original jurisdiction judicial proceeding. And if that's the case, is there any kind of difference? They said that the Sierra Club has established a legitimate claim of entitlement to a clean and healthful environment under Article 11, Section 9 of the Hawaii Constitution, for any of you who want to go look it up. And they said, let's apply the Roth factors, and the risks of deprivation are high, so they get a seat at the table, and they all but winked and nodded at the PUC that upon remand, the case better come out a certain way or they come back on the merits. And so in the footnote, and this is again why I find this case interesting, it is not simply a matter of statutory or other law. The Supreme Court of Hawaii immunized this from any kind of legislative tinkering by reminding the legislature in a footnote that this is based on the constitutional notion of property, and therefore it's off limits from legislative tinkering. The legislature cannot go and undermine the property right to a clean and healthful environment. Two justices disagreed with the usual type of disagreement that you might expect in these type of cases, saying what's next? What's the other shoe that's going to drop after this, the slippery slope or the Pandora's box argument? And they said, really, and in the end, it's kind of unnecessary. Why did we even go here? Because the one fact I didn't tell you is by the time this case reaches the Hawaii Supreme Court, due to the death by 1,000 days that we sometimes see in environmental litigation, the whole thing collapsed on itself because of the delay brought about by the challenge, and the finances of it collapsed, and the power plant was never going to come online in the first place. But the court avoided any mootness problems by saying, well, this is just one of those public interest type of things that we have to resolve. Needless to say, I saw that as a bit of reaching out to reach the result, which tells you to me that this is not the first shoe in this sort of series, that there are more shoes to drop. And it also raised to me, as someone raised in the common law tradition, of, well, if this is property, and I understand the idea of new property, but this seems a little different. This isn't, necessarily my individual property as Professor Roth against the regents, the world, enforcing my right to a notice and hearing. This seemed to me to be a little bit more. And it seemed to be, again, I think the critical part is it's not an individual right. It is a right, a collective right. And at that point, if we completely undermine the notion of property, even though the Hawaii Constitution's due process clause, much like the two due process clauses in the United States Constitution, does not say private property, right? It says simply shall not be deprived of property without due process of law. Is that some kind of, are we seeing a new opening here? And I don't think the court adequately grappled with the notion of how the foundational question that was built into the argument, that should these types of environmental concerns, can they and should they even be shoehorned into the concept of property? Because I think it was Jim, you raised, the idea that, Penn Central, or I'm sorry, not Penn Central, of Pennsylvania Coal against Mahon, we often refer to that as the first regulatory takings case, but I think it's quite conclusive that that's far from the instance, at least with respect to state courts and state constitutions. Chancellor Kent, right, in the Gardner case in 1816 in a water case, said the diversion of water away to make me lose my riparian rights via a local municipal ordinance should result in compensation. He did not call it a regulatory taking, but those of us today who do this stuff would certainly recognize that as a regulatory take. Maybe a physical regulatory take, but a regulatory take nonetheless. And if you want to go back even further in time to Lord Cook and the saltpeter case. Again, I forget what year that was, but it was around the time of the formation of this law school, the 1600s, whenever Lord Cook was doing his thing, and where the courts or the law lord said, yes, the king can come onto your property and remove saltpeter for the defense of the realm because it's useful to make gunpowder to repel the invading Spanish, but the king's agents must make the property owner whole or indemnify him. Again, looks a lot like a physical appropriation, maybe even a regulatory take. So this is not entirely a new concept. And so we have another court, at the same time, and I don't think it was a reaction to the Hawaii court, but it certainly kind of matched up. Those of us who look at this stuff liked sort of the contrast because the next year, the D.C. Circuit, applying Pennsylvania's similar constitutional guarantee. The Pennsylvania Constitution has a somewhat similar guarantee that they call the Environmental Right Amendment, and they say it guarantees clean air, pure water, and the preservation of the natural, scenic, historic, and aesthetic values of the environment. And the court in that case came to the exact opposite conclusion in a case that was much procedurally very similar, except it involved, since it's the D.C. Circuit, a federal agency, FERC, Federal Energy Regulatory Commission. And the question there was, did the Delaware Riverkeeper Organization have standing to challenge? And the court, like the Hawaii court, said that there was Article III standing, but the problem was, did they have a liberty or property interest entitling them enough to give them due process protection? And the court said no, and it applied what us common law lawyers look at as a very straightforward. They said, if something's owned by everyone, it's really owned by no one. You can't exclude somebody. The most fundamental aspect of the right to exclude is, or the most fundamental aspect of the notion of private property, and the court assumed it was private property, is the right to exclude. And how in the world does one organization or person exclude everybody else? If it's something you all share, is it truly property? And the court said no, that in this case that simply doesn't qualify with their notions of private property. And so the question I've had based on those is what's next? what's the other shoe to drop? And I think on this one, maybe our little crucible out in the 808 area code is going to be where this is. Professor Merrill, you came to our jurisdiction a few years ago and talked about the Kauai Springs case, a case involving our little version of what no Roman law or English law lawyer would know as the public trust, but which we call the public trust. And it's essentially this concept that certain elements, in this case, all water in Hawaii, none of it is subject to private ownership by declaration of the Supreme Court. What that did to 150 years of common law of riparian ownership and correlative rights and other things simply went out the window. And when challenged as a judicial taking, and this is kind of our next subject that we're going to deal with Justice Bell with, is to what extent, who defines these things? Who defines this law? How much leeway do states have in changing the law before they are subject to the compensation requirements? And we all know, right, that what's the rubric that every court has cited probably 10,000 times about who defines what? Who and what entity defines property? State, right? State law, common law, state law, right? I mean, you'll get issues of federalism and otherwise. You'll get issues of there's no such thing as the federal common law of property. Yeah, right, look at Murr, there's the federal common law of property if you want it. But this raises that question. And before we transition to Justice Bell and taking that question and asking not only who gets to talk about and define state property or property law in general, but how malleable is the term, right? Because as I think Professor Calley, as you pointed out, if the term is infinitely malleable, if a background principle is completely be able to define by state law what's left of the takings clause if it requires a definition of property that is completely malleable under state law. Look at this case, Ninth Circuit. And it's up on a petition for cert at this point, but the Ninth Circuit, which is somewhat surprisingly, given its reputation, right? Ninth Circuit, we always joke that the best way to win in the Supreme Court is to lose in the Ninth Circuit. Not so much true anymore, but it's maybe true. The state had argued the case arose. It's a class action alleging that state officials failed, quote, to return interest that was allegedly skimmed from the state-managed retirement accounts. So it's a classic taking. I had a deposit on file with you. It was supposed to gather interest or in a certain way and a certain rate. You didn't do that. In fact, it was changed by the state legislature. The state legislature changed the law to recalculate the way interest was calculated. And as a consequence, there was a takings claim. So the question was, how malleable could the state, if you're entitled to interest as a matter of fundamental principles, but what if the state can say we're going to calculate it on a daily or on a monthly basis versus a daily basis? And the Ninth Circuit in the 2-1 decision reversed the lower courts and said that wasn't a taking because there really wasn't any kind of property interest, or if there was, it was thoroughly defined by state law. And the state argued that the Court of Appeals, the Washington Court of Appeals, held that the statute didn't require the taking of interest because it had been amended. There really wasn't any property at all. And again, the Ninth Circuit sort of surprisingly, in a 2-1 decision, written by an President Obama appointed judge, said that there are certain, this kind of looks like one of those fundamental, quote unquote, or core property interests that is defined by something else but the state's ability to completely rewrite it or even alter it in a significant way. And so the question is there, what is the source of those property rights? Is it natural law? Is it something else? Well, it certainly is not positive state law because the positive state law changed what the property interest was. And who knows? I don't know. I haven't checked the docket yet today, but I think it might have been up for conference the last couple of days. So we'll see if the court wants to step into that morass. And my thinking is it probably won't, for the very same reason, because because the Stop the Beach case was so clear at the end, right? I mean,
It was
you
so
gave us
well
such
written.
clarity on this question of who gets to, what's the source of the property right, who gets to talk, who gets to mold it, and what are the consequences of that, right? That, I'm kidding completely, of course, that did not solve the question. But before we get to Justice Bell, and that, let me say, thank you, Linda, for asking me to do this. I've said before that being here is like the Super Bowl. This is free property law. It's Yankee Stadium in October, right? The Champs-Élysées or Wimbledon in July. This is it. Although I kind of kid, given the stellar nature of the speakers here, I kind of feel like it's Wimbledon, but I'm the poor person who got lined up against Venus Williams, But, and second, a very hearty congratulations to a very deserving winner this year in Stephen Eagle. All I would say is that there are a few books I keep on what I call my back bookshelf, and those are the ones that when I turn around at my desk I can grab. His is one of them, one of about 3, along with my rule books. And so, very, very deserving award for your wonderful work and scholarship. Now, I want to take that, and that takes us to our next session. Do you want to sit, stand? I mean,
I'll sit.
Okay, let's turn to the Stop the Beach case, because I think, our old friend Stop the Beach really brings up a lot of these questions on new property, old property, new property, whatever you want to call it. And we have with us today Justice Bell, who of course wrote was it a majority opinion, or was
Yes.
it was a majority opinion for the Florida Supreme Court, and was sort of the putative defendants, I suppose, in the judicial takings claim that gets raised for the first time or in the cert petition. And before we go to that, I'd like to do a little summary of what the issues were, and then we're going to turn it over to Justice Bell and ask him to tell us, the Supreme Court get it right. What did your court do and why? And what do you think some of these issues are? Well, quickly, renourishing beaches is what they do when they essentially take sand from offshore, bring it closer to shore, and create or recreate beaches that have eroded away. And under the Florida statute, which was adopted, 1961,
Right.
I believe, early 1960s, the newly created or recreated beach or replenished beach would be owned by the state. And so what happened was you had some littoral owners whose properties previously bordered or touched the ocean and therefore had, they believed, certain rights, claimed that was ultimately a taking. And it was they claimed that the Florida Supreme Court rewrote the law of accretion, which normally said that the public-private boundary between littoral property and the ocean would essentially follow wherever the beach went. The Supreme Court, none of the justices agreed with that it was a judicial taking. Some of them, the Supreme Court justices, said there's just no such thing as a judicial taking. 2 of them. They said that was simply a due process problem. It's never going to result in compensation. 4 of them said, well, this could have been a taking, judicial taking, but it ain't in this case. And then 3 of them said much the same thing, leading, I got to leave it at this one, the oddest passage I've ever read in the Supreme Court opinion, where Justice Scalia said, how much wood would a woodchuck chuck if a woodchuck could chuck wood, was essentially the metaphysical question that the dissenters failed to answer in the case. Okay. So in certain circumstances, it's still, the door is sort of there. It's not very wide open, but it's still theoretically cracked open for someone to challenge a state court exercising its judicial authority to interpret state property law, that may result in a compensable taking. Whether that has changed because the composition of the court has changed, I don't know. But I'd like to, at this point, turn the microphone over to Justice Bell and give us your thoughts on both what your court did and what you think whether you think the Supreme Court got it, the U.S. Supreme Court got it right, and where, if not, where did they go wrong?
Well, they got it right because they didn't overturn me. But for different reasoning. For background, I was a board-certified transactional real estate attorney, then I was a circuit judge for 12 years, and I was on the Florida Supreme Court, and the only one on the court with any background in real estate law. And so I was a big supporter of private property rights, obviously. And as was discussed earlier, I had a very complex case in trying to manage the competing rights and responsibilities. So I'll tell you, because I think a lot of you may know of the case or heard about it in property law later. I haven't dealt with it since 2008 when I wrote it, but it was really fascinating on a personal level. I had stepped down from the Florida Supreme Court in October, and it was argued before the U.S. Supreme Court in December. And I got to sit, if this is where the podium is, where the arguers at the Supreme Court were. I was in the seat right here, and the judge in the lower court that got reversed, who is also from Pensacola, was beside me. So we were elbowing each other as the case was being argued. And there were a few softballs that were thrown by the justices that I was really wanting to stand up and answer at the time, but I restrained myself. But basically, what happened in Florida with the Beach Restoration Act in '61, Florida, as you know, has 1,200 miles of beaches. And we have a lot of hurricanes. We have a lot of erosion. And so they came up with this act. And basically, over near where I live in Pensacola, there was a permit issued to restore beaches. There had been a series of 5 hurricanes since '95 up to the time of the decision or the permitting. There had been a series of hurricanes that had severely eroded the beaches. So where the mean, if this was the mean high water line before the evulsive events, the mean high water line had moved up to here. So what the state would do, without any cost to the private property owners, they would come in and pump sand from offshore and rebuild the beach so the property line would go back to the mean high water line where it was before the evulsive event, but then they would build it out a little bit so it would last a while. So there'd be some separation between where the mean high water line, and when they did that, let me back up, when they did that, then they would fix the boundary line. So what the private property owners were saying, well, wait a minute, under common law, that our boundary is supposed to meander. So I have a right to accretion or reliction, and you've deprived me of that right. I have a right, separate right to have contact with the beach, and this action is going to deprive me of that right. And so it came to us as a court, and as I was telling you yesterday, what the epiphany basically to me is, and we talked about are there public property rights, is the way I viewed it was you had adjoining property owners. You had the private property owners, and then you had the state, which held the sovereign land underneath that was sovereign land and held in public trust for the people. And I don't think anybody would dispute if these were 2 adjoining property owners who are private property owners and there had been an evulsive event, then everybody agrees that both property owners have the right within a reasonable time to restore the property to its pre-existing boundary line. So that was the essence of where it came to for me was, if that's true, then the state, if a private property owner has the right to restore after an evulsive event, why wouldn't the state, if it's the underlying property owner, have the right to also restore to that line? And then you get, so if you accept that as an evulsive event, and that's the concomitant rights of both sides, is then what happens to accretion and reliction and those other things? Well, my view was, well, to answer that question, you had to go back, which was undefined, and we went back hundreds of years, was what type of property right is the right to access? The riparian right, what's the nature of it? So under Florida law, some courts had called it an easement. Well, if you think of it as an easement, then you have a dominant estate and a servient estate. And as you all know, in basic easement law, a servient estate holder can modify the easement to certain degrees and the rights of the dominant estate holder to use it as long as it's not unreasonable. So that's the paradigm I was looking at in my mind. If this was the mean high water line established, now fixed, then, and we were looking at it on a facial basis, if that line got fixed and this property owner has the littoral rights of viewing, of accessing, and reasonable use of the waters, the only one at issue was the right of access. And on a facial basis, if there was an unreasonable deprivation of their right of access, for example, if the state didn't build it out 100 yards or 200 yards, where you don't have a reasonable access to the water, then that's a typical right of a servient stateholder in any easement situation. You won't find that in the opinion, but that's the rationale I was coming from through my head. And then if you go back to the basic idea of what's the rationale for accretion and reliction, and I cited in the opinion, but cited in Blackstone and in another court, a Florida court afterwards, there was what Blackstone called reciprocal considerations. You have the right as the littoral owner to accretion and reliction, but you also suffer the erosion or the loss of the property. And the courts don't deal with minimal changes like that when you have those minor changes. But that's why there's a different rule applies when it's an avulsive event, is because when you have the avulsive event, you have the right to go back and restore. And so I go through all of that in the opinion, and I basically, that's how I'm thinking in my mind, is if you have reciprocal consideration, and the idea was to try to balance the competing interests of the public and the sovereign land that the state has to maintain on behalf of the public and the private landowners, then I saw that as basically the way I phrased it it suspended the right to accretion. Because the way the act is written, if the state doesn't restore the property within 2 years of the permit, or it fails to maintain it, then the mean high water line goes to where it was before, and it meanders from that point. So I call that suspended. And I relied on that basic common law in Florida and Blackstone and basic principles of American common law of avulsion. So that's the way I looked at it. There was a right of the state to restore the beach, to reclaim it, and put it back in the position it was before. Well, interestingly, when it went up to the U.S. Supreme Court, they relied on a case that I intentionally ignored because I didn't like the potential implication. I didn't want to reemphasize it. But there was a Martin v. Bush case where the state had, it was an artificial avulsive event, is where the state went and they lowered the level of a lake so that the lake owner didn't have, wasn't touching the water. The lake went further out, and so the lake owner was saying, property owner, the riparian owner in that case, said that his property line went out to the water, and the state said no, and the Florida Supreme Court said no, that wasn't an avulsive event. And to me, there's a difference. How does that balance the reciprocal considerations of the law if the state can unilaterally go out and move the boundary line? How is that an avulsive event if it's artificially done without it being a taking? So I wanted to avoid that issue, but for some reason, instead of relying on Sand Key and the other cases I relied on, if I had any criticism of the court, but the concern about for private property right purposes is in affirming me, they didn't disagree with my analysis. They just relied on a different case, Martin versus Bush, and they basically said the right to accretion wasn't at issue, it wasn't implicated because the state has a superior right, and the superior right is to restore the property, and left it at that. And that bothered me because, again, as I end my opinion in the case, I said this is a facial challenge, and it's not one where the state has overacted or there's no evidence before the court at the time that the littoral owners had been adversely affected. In fact, they had been benefited because their property was restored, and that issue wasn't before the court. So when the U.S. Supreme Court basically goes back and says, well, under Florida law, the state can artificially add alluvium to the parcel, and that's not a problem, and so we're just going to rely on state law. So anyway, that was the case. I think my decision was better, but I had to laugh. I had a law partner after I got off the bench who was an environmental law, got his LLM here, and he told me before the decision was decided, you got that one wrong. And so when it came out 9-0, I printed off and I said, I got it right. So I'll take it.
All right, thank you all. So we still have a few minutes left for audience questions. Does anyone want to ask our panelists the question? Professor Romero? And then you can pass it to Professor Clapp.
Yeah, sort of a comment on Bob's presentation. In Illinois, since 1970, the court has maintained that every citizen of Illinois who's a taxpayer has the right to invoke the public trust doctrine. So Illinois has had this kind of universal state law right for a long time. Recently, two high-profile federal lawsuits were filed in Illinois, one challenging something called the Lucas Museum of the Narrative Arts, which is to be constructed on an asphalt parking lot near the lakefront, and the other challenging the Obama Presidential Center, which is to be built in Washington Park near the lakefront. And in both of those cases, the federal district judges endorsed the argument that because every citizen has a right to bring a public trust challenge, every citizen has a property right for due process purposes sufficient to invoke Section 1983 and bring an original action in federal court. Now, if this Seventh Circuit's going to hear the Obama Presidential Center case, which Professor Richard Epstein is handling for this group of challengers on a pro bono basis, but I'm hoping the Seventh Circuit will follow the D.C. Circuit and nix this theory, because the consequence, at least in Illinois, is that now every public trust case can be decided by a single federal judge. And there's a lot of evidence that the politics are different in every state. Now, in Hawaii, state courts are sort of, in the environmental camp.
Yeah, they're free-range courts.
Right. In Illinois, there's significant evidence that the state court judges are highly sensitive to what the dominant political forces in the state want to do. The federal judges are a different matter. They're kind of like, they've got life tenure, and they sort of sympathize with some of these environmental activist groups a little bit more. So. If this theory is, which is basically the one you've been describing, of universal due process rights in the state at least, is accepted, you now have a choice of federal or state court, and you can go to federal court if it's more to your advantage to try to upset what the majority wants to do with natural resources.
Yeah, I definitely think it's.
I want to make just a quick comment on that. We have a Constitutional Revision Commission every 20 years. And there was a big push that had been pushed 20 years ago, but really pushed really hard this time. And fortunately, they didn't accept it and propose it to the people for vote, but to give every individual, it didn't have to be a Floridian, any individual, the right to add that to the provision on the right to a clean environment, gave standing to any individual, again, not even a Floridian, to bring a lawsuit to enforce that right. And the impact on private property interest and others was just incredible. But I assume that's happening in other states too.
And the effect is to transfer authority to the courts to decide. Right.
I've got a comment for Bob and a question for Henry. So for Bob, I thought it was interesting that in Hawaii, it sounds like their Public Utility Commission, you actually need a property right to intervene in the proceeding. In most states, and certainly in Minnesota, you need an interest, and you'd have an interest that's adversely affected, and no other party to the proceeding is representing your interest. So environmental groups routinely are participating in all energy generation decisions, and in fact, in a PUC proceeding recently involving the controversial Line 3 oil pipeline, a group of youth climate interveners separately intervened, saying that because they were they were youths, the traditional environmental groups weren't adequately representing their interests. So it's interesting to see that in Hawaii it needed to be based on a property interest.
What I left out was that our PUC statutes were written in such a way, I think if they were writing them now, they would have included that, but the court interpreted them not to have statutory standing. And so this was the second of this was the alternative argument, saying, well, if we don't have statutory standing, then we're going to have constitutional standing. And the court, oddly enough, I thought that was the easy way out, and they would have got all 5 justices on board by actually interpreting the statute to say, you've got standing, we don't have to get to the tougher constitutional question. But the three in the majority, I think, sort of blew by that one and went straight to the constitutional argument. But they did have that. And it was enough of that one was a close call on, statutory interpretation. But that's why I kind of left that out in the interest of time. But that's exactly, that was the approach to the case. Yeah.
Then a question for Henry. So I agree with you completely that nuisance law is a flexible and a sort of appropriate way to address complex problems, including environmental problems. And I'm assuming you're referring to both public nuisance and private nuisance. You didn't distinguish between the two, but assuming that you would see that both ways, I thought it was interesting you didn't mention the most complex environmental problem that we have, which is climate change, and the appropriateness of using nuisance, whether it be public nuisance or private nuisance, to deal with climate change related damages. So I'm curious as to your views on the there's now a lot of lawsuits brought by local governments in one state against fossil fuel companies to recover climate adaptation damages using, among other theories, public nuisance, state public nuisance. So I'd love your thoughts on that, because that would seem to be sort of the perfect example for your theory of using nuisance to address complex environmental problems.
Yeah, so I had thought about adding this, but it got left out for time for 2 reasons. One is that, as I said, with respect to water, I do think the common law runs out. And I do think that when it comes to very widespread problems like climate change, legislative solutions are usually better. Now, I know that, legislative solutions aren't always forthcoming, and from the judicial point of view or from the litigant's point of view, public nuisance is very attractive in many ways. I do think, I don't have sort of very strong views on the exact contours of public nuisance. I do think that it's a sort of, the idea that it's kind of like private nuisance with the doors thrown open is kind of an artifact of the restatement process. The restatement of torts, other parts of the restatement have started dealing with public nuisance. We'll probably have to deal with that. So I think anything that I would say beyond that, I'm a little skeptical of Prosser's handiwork, would be kind of premature. So I think they're ultimately, yes, I think in principle, public nuisance and, for that matter, equitable solutions are on the table, but I do think that there are institutional choice questions that implicate legislatures more than a sort of common law is potentially everything kind of view, which I don't hold. But where the line should be drawn and relatedly what the exact contours of public nuisance should be are definitely a work in progress in my mind. But
That's the issue of the day, right?
no, it is the issue of the day.
Well,
but-
this may be the
Definitely the issue of
minion,
the day.
this may be the minion version of looking at it, but if you have to protect the environment, and it's done by regulation and legislatively, that's the only way to do it and deal with the complexities versus giving some private or public nuisance claim under the common law. Because if I'm a business owner and I've complied with every environmental, state, and federal regulations, and then I've met all of my obligations to the public, and systematically, that's the only way to deal with it, to me, in an orderly way, versus giving individuals or individual groups or whatever the right to say, no, I don't like it because you're affecting the environment, but I've done everything the state, the regulatory body is telling me I have to comply with and do. Why in the world would you invest somebody with standing to go into the judiciary? Because the judiciary is not capable, as you mentioned, of handling the complexity of the thing. So the way you deal with it is through legislative efforts, in my mind.
Although, just to clarify, these are claims not for injunctive relief, but for damages.
But why would you have a right to damages if you've complied with every permit that you've been, unless you could actually show, substantively show damage versus, sometimes you can, yeah.
All right, do we have one more quick question? Anyone up in the back there? You can start shouting out. Yeah, sounds good.
Yeah, what do you think of the Juliana case, the 21U case, where the claim is that the substantive due process rights of kids are being denied by the failure of EPA to address climate change, which will inevitably mean a lot of them short of nasty, brutish, and short. It's a claim for, not for damages, but for action by a regulatory body.
Yeah. I'll throw my 2 cents in. I don't trust 30-year-olds to make decisions on it. For whatever that's worth. And if standing's a question, they should have come to Hawaii court, because we'll let them. No, and the relief troubles me because, as you know, there's a lot of discretion in the government when to enforce laws and how to enforce them, and to adopt a rule that says that in certain circumstances that you can compel the government to exercise its discretion in a particular way. I'm all for limiting the discretion of government in most cases, but I'm not sure that isn't a recipe for complete chaos. If we're going to do government by injunction or writ. To me, that's a tough sell. Yeah.
All right, thank you for the questions. Thank you to the panelists.
Thank you, guys. That's fascinating stuff.